Hi, this is Kent Jones with Jones & Associates PC. We cover Hamilton County, Bradley County, McMinn County, Polk County, Marion County, and we go into other areas on an as-needed basis. I'm going to talk to you today a little bit about divorce and child custody. Historically, it used to be a preference for the mother to have custody of the children, but that has changed over the years. As of today in Tennessee, we have fallen in with most of the other states, and custody is essentially based on the best interest of the child. What this means is a lot of things. There are a lot of factors to be considered. Obviously, if one parent has hurt or murdered the other, then the other parent will have custody. That's a major consideration. Instances of domestic abuse will come into play, and in most of our cases, this occurs quite a number of times. One of the more simple considerations is the court's view of the parent's love for the child and willingness to be a caretaker and ability to provide for the child. The overall relationship between the child and the parent is a significant consideration. Historically, the courts would allow a child that is 12 years old or older to testify about how they feel. There's been a movement lately to allow children that are younger than 12 to testify if they are capable of doing so. In regard to a parent's desire to be a caretaker, a loving caretaker for the child, then the courts are going to be very concerned with that parent's ability to provide food, clothing, education, and medical care for the child or children. If that is not clear in a divorce action, two things generally happen. One of the things that can happen is one of the attorneys can petition the court for a guardian ad litem, or the court can appoint one on their own. Traditionally, a guardian ad litem is an independent attorney who is brought in and given the power to investigate the households where the child is going to be living, the circumstances regarding the household, how many people live there, who lives there, and many other factors. The economic capabilities of that particular parent, and then they will produce a report which is filed with the court, and the cost of the guardian ad litem are split evenly between the parties. A more cost-effective approach from what generally happens in cases of disputes over custody is that these matters are eventually brought to mediation. It's good to use a Rule 31 family law mediator, and we know of quite a few in the area who are very good at this. There are two types of mediation now. One of them is where the mediator puts everybody in the same room the entire time until everything is worked out. Personally, I don't like that type of mediation. What I like is for the parties to be put in separate rooms and develop their case with the mediator, so that the mediator clearly has an understanding of each party's individual concerns. Then everybody meets in one room, and everything is put together kind of like a puzzle. And usually mediation works, and ultimately the mediator will resolve the matter, and his or her opinions will be put into writing, signed by everybody, and we will end up putting it into an order and filing it with the court. Some mediators are expensive, some are not. Some mediators have minimum time periods, others do not. It's important, if you're going into mediation, to get with your attorney and start working on a mediator that is suitable for you, and then you have to have an agreement with the other party. It's a little bit of compromise on both sides. Later on, if there is a change in circumstances, courts will consider petitions for modifications of a child custody order, but the changes do have to be significant, because the courts really don't want to look at little minor things every other month and say that that's a consideration that warrants a modification of the order. If you have any questions, we'd be happy to answer them. Jones & Associates PC is located at 140 North Ocoee Street. I'm in Suite 290. Brad Wilson is in Suite 220. Brad's background, he did e-discovery for a very large firm in Atlanta, and then he did child custody and child support for the city of Cleveland for a period of 20 years before going out on his own. He's joined us as of counsel. You can contact me at 423-424-6208. My email is joneslaw08@gmail.com. Bradley and Wilson is located at brad@bradleywilsonlaw.com. His telephone number is 423-458-2479. If you don't catch either one of us, please leave a message, a detailed one, confidentially, and we will get back to you ASAP. Thanks a lot. I hope you enjoy the rest of your weekend. I'm a Tennessee fan, but go Alabama. Bye.